Hi, I'm Arlin Crisco, and I'm here with Dr. Burton Bentley of Elite Medical Experts. Dr. Bentley, how are you doing today?
Pleasure to be here, Arlin. Doing well. Thank you.
Fantastic, fantastic. Well, I'm eager to jump into what we have to discuss today. Today's going to be a really interesting topic, I think. You know, the typical medical testimony masterclass episode, we break down medical expert testimony of videos and trial that we cover here at CBN, all with an eye toward helping you become a better trial attorney. But today we're going to take a little bit of a different tack. We're actually going to talk about what you can do with your expert and how you can select your expert and things to keep in mind to maximize the chances of getting that powerful testimony that will help you win the battle of the experts in your next case. And I think that's a really important discussion. We're going to talk about the pitfalls to be aware of, as well as some pearls of wisdom to kind of keep in mind along the way. And like I said, I really think it's important to discuss that. And I'd like to thank today's sponsor, Elite Medical Experts. They're really making this episode possible. And if you don't know about Elite Medical Experts, they are one of the top firms aligning trial teams with some of the top tier medical experts around the country. One of the things that really impresses me about Elite is they're not just an expert referral service. You don't get on any list of experts with Elite. Instead, you would contact Dr. Bentley and his team, and they would discuss with you the particular circumstances of your case and what you need a medical expert for. And then they would dig into their knowledge and their experience with medical experts around the country to match you with a top tier expert that will address those needs and circumstances of your case. But beyond that, they'll help you navigate any of the problems along the way, all with an eye toward ensuring you have just what you need to win that next battle of the experts for you. And that's why I really think you owe it to yourself to contact Elite and check them out. It's elitemedicalexperts.com. And in fact, if you mention CVN, you'll actually get a significant discount off of your next medical expert placement. So that's elitemedicalexperts.com. I'll throw a link in the description box on the YouTube channel here. But I would like to thank them because this is a really important discussion today. And frankly, Dr. Bentley, I don't think there's a better person to talk about this than you. I like to call you the expert on medical experts.
I appreciate that. We've crossed close to 14,000 cases, both plaintiff and defense.
Wow.
Aligning top tier experts, nearly exclusively university physicians and surgeons. We can kind of cover that and how that really gets into our topic of battle of the experts, how we get the best expert in the race. But I do believe that gives us just a tremendous advantage in understanding these cases strategically, tactically, and really what it takes to win. So thank you for that.
For sure, for sure. Well, let's jump right into it then with the old adage, I guess, is to get to the pearls, you have to avoid the pitfalls. So why don't you talk with us a little bit about the pitfalls and what you see as the major pitfalls that attorneys encounter when selecting a medical expert, working with medical experts along the way?
Sure. And then we'll come full circle to how do we get that ideal medical expert in the first place. But regardless of who you're working with, there are horror stories out there. Experts are just people, and we see things go awry from every possible direction. And we've spent a lot of time dissecting what has gone awry to look for common threads so we can avoid these things, move beyond it, not just fix them. You know, how do we prevent them? And I would tell you, in looking through countless encounters, and these are cases we're getting from around the country where something maybe has imploded at the 11th hour, the common thread is nearly always communication. And that seems super general. What do we mean by just communication? But I think if you look at the core of that, it's misunderstandings that crop up in cases. The legal team has their journey. They're trying to push this case forward and win it in the end. The expert has their journey. They're a busy physician, surgeon, who thinks medical legal work is pretty interesting and is getting involved, but those journeys don't necessarily align. So we're huge on how we get ahead of communication issues proactively, preemptively, so that we're not cleaning up mistakes. And some of the most common mistakes we'll see, and it seems almost funny to talk about it here, but for example, we'll get a call, we're 8 months into the case, and boy, we've got the wrong expert in this case. We just learned today that He doesn't use a certain type of a pacemaker that's relevant to this matter. How could we be there? Or an expert unexpectedly seems to have done a 180 under cross-examination. They're at deposition and something comes out of the blue and an attorney is stunned. Or it's an expert who's difficult to work with. Attorneys having all kinds of trouble tracking them down, or what we've all seen, someone who's overbilled. You're working with an expert, you sent them an emergency medicine chart, you think it'll take them 45 minutes, and you get a 14-hour bill. Those are all common scenarios. And the amazing thing is, it's a miscommunication that permeates each one. So when you have the wrong expert for the case, somewhere along the line, someone has failed to confirm their expertise, to talk about what's needed, to cover everything, to talk to them about why they're the right one. When someone implodes on cross, why hadn't you discussed strengths or weaknesses in advance? Why hadn't you done adversarial role play, anticipated complex questions that are about to come their way on cross, not the kind of questions on direct? We should never be surprised by words that come out of our own expert's mouth. An expert who's difficult to reach or communicate with. What types of things did you set up? What expectations? Have you traded cell phone numbers? We'll talk about that in a while. Why weren't expectations outlined so that they knew you were trying to reach them? And overbilling, we have an entire system for how to prevent that. There's no such thing as a runaway checkbook. That is a communication issue. Barriers or speed bumps need to be put down so that there's deadlines, deliverables, expectations. I could give you dozens of those examples, but everything really comes back to these important threads of communication. And it's something we really work with people on to understand the importance of just engaging in a respectful cadence that achieves the objectives of the case and doesn't leave these pitfalls just sitting in the open because they're so predictable.
Right. And given those breakdowns in communication, how do you look at avoiding those or the red flags that might show that those are coming down the road with a particular expert?
Excellent. So very often there are red flags and we want to avoid those out of the gate. And once we've got who we believe to be the ideal expert, we want to navigate it appropriately. So red flags are avoided pretty easily during those initial conversations you have with the expert. So people that are working with us, we have an experienced team. So not only are we taking the time to understand the global elements of the case, but I'm looking at the strategic elements, I'm looking at the tactical elements, and then I'm looking almost in a central casting role, who's best to tell this story, not in a spurious way, not getting an opinion out of someone, but who's the best voice, because ultimately that's what an expert is, the person telling your story on the stand and educating the trier of fact. So we spend extraordinary time with our clients understanding what this case requires from every dimension. Then when we set out to align experts by hand, we're developing that target list. Who are the people with whom we want to reach out? And then through an interview process, that's where we can take the time to really understand someone's engagement, bandwidth, temperament. And truthfully, is this someone I enjoy or my team enjoys speaking with on the phone? Is that the person I want out there telling the story for our client? So those are the things to go through. And I always want to be careful. It's not about getting someone's opinion. Well, doctor, what are you going to say on this case? Nobody knows till they get in the records. This is all of the foundational elements so that we're at least teeing it up for success. And of course, that's supported by already having vetted an expert's background and publications and experience to assure that they're the right person on paper. Then we're moving that next step to avoid some of these pitfalls.
Fantastic. As far as the initial meeting too between an attorney and an expert that's selected, or potential expert, that seems like that is probably the most critical meeting to set those expectations that you're talking about and get both sides on the same page. Is that right?
It is. And so we definitely have clients who rely upon us solely. Hey, you've already interviewed them. I know you already know the medical particulars. If they've passed your screening, then we're ready to go, and we send out records. Nonetheless, we advocate everybody speak first. I'd rather have two sets of eyes on an expert. It gives a second chance just to see how accessible they are. How much do you enjoy speaking with them? How dynamic are they? So again, not about going through all the facts of the case, but we sometimes call it just a meet and greet. So I'm a fan of that. But during that same call, it's a great time to outline just what I call deadlines and deliverables. Sort of a broad way of saying, what do we expect for this engagement? Hey, doc, I think this case, might wrap up in 3 months, or this one, everyone's pulling out cannons. It could go on for a solid 2 years. We're expecting multiple experts. Here's where things will shake up. So sort of letting people know, where are you at with it? What are you expecting with them? How complex is it? Are you about to send them the proverbial banker's box, or is it a limited set of records? So again, by sharing those things and making sure everyone's aligned, it allows people to self weed, so to speak, to recuse themselves if it sounds like too much. But I think more often what you find, it's a good chance just to align, to meet, and to get a little of that interest and engagement going so that the case moves smoothly.
Right. Now, you had talked about a lot of these pitfalls that you see happen because of miscommunication. Are there any other kind of root causes, or is that the central one?
Well, we see a lot of mistakes made out of the gate. Literally, someone has picked the wrong expert. Most common thing is wrong specialty. So it changes seemingly every day, but there's about 286 medical specialties and subspecialties, and they get more and more refined every year. So it's just incredible, the resources that we have to get the exact right person. And it's incredible how many mistakes people can make, either missing the optimal person or getting the wrong one. So many specialties sound similar, and we'll see the classic mistakes made. Someone thinks that they need a cardiologist, but it's really a subspecialty of cardiology called clinical cardiac electrophysiology. If you have the wrong person, for those initial 5 calls, they may sound great. And then you realize, gosh, they don't use this type of pacer or cardiac treatment. So I'm really big on just avoiding the obvious things out of the gate, doing some background checks, publications, board certification. We'll dive into social media. I think that's important and very relevant because opposing counsel will, so you might as well discover it first. And we've had a lot of experts who couldn't pass that test. Something crazy has been posted online. So I think, again, filtering down, and we'll talk in a moment about what we call this Venn diagram construct. But how do we filter down to get the best person? It's not a guarantee, but let's at least avoid the obvious pitfalls right out of the gate.
Right. Now, that brings up an interesting question there that I know a lot of attorneys struggle with, and that is, at what point do you reach out to an expert? What point do you start seeking an expert? Very early in the case, or do you let the case play out a little bit so you have more details, a little more discovery on it, that sort of thing, before you reach out? What are your thoughts on that?
So every case is different, and we get them at every point along the continuum. So there's some cases that are just coming in as the earliest exploration. The proverbial, 99 cases out of 100 aren't worth taking. How do you know the one that is? So some cases, it's a matter of just screening and filtering to get down to the ones that you even want to consider taking further. Some people use experts at that point. Some law firms that are more established may have some in-house, healthcare providers who can do some initial screening. So some people need experts consultatively out of the gate. Some people have already filtered down those cases. Now they want to assure that they're on the right side. In that situation, some people will still use experts consultatively, potentially non-discoverably. But at that point, if people are relatively sure that they're on to something that's worth exploring, that's typically when an expert's engaged. One of the biggest mistakes we make is someone thinking that they've got a case completely understood and they've already set out and filed, and maybe they're even taking depositions, and they haven't got all of their experts aligned. Maybe they've got a standard of care person, but not a causation expert or other key players. I'm a fan of, when you need experts, you need experts. These cases are complex, and they can be a complex rabbit hole, and that's on plaintiff or defense. You can spend tens and if not certainly north of $100,000 on experts. And it behooves you to learn early, not just the views that support, oh, this is the greatest case ever. We're huge on the contrarian view. What are you going to find out when you get deeper into the trench on this case? So hearing all of that up front, even if you get an expert who's negative, is valuable information. Are they right? And you shouldn't be taking the case? Or is this a pitfall that you need to navigate? So I'm always going to push for bringing in people sooner rather than later. It doesn't mean giving them an open-ended checkbook, but it means, gosh, let's get some resources because litigation's complicated.
And that's one of the things that I like about Elite so much, is because you all do help attorneys navigate that issue, that kind of stair-step issue of when do we need an expert and what expert do we need at this given stage of the case.
We do. And I think one of the things that shocks our clients the most, we'll get calls about, hey, this case is going to need 3 experts. Let me explain it to you. And sometimes in engaging, we're just pausing and saying, gosh, strategically, you may ultimately need 3. But if this case falls apart on causation, I don't need 2 people on different aspects of standard of care. Why don't we start with the causation piece? And that's most common actually in oncologic cases. There's a delayed diagnosis of a tumor. So let's say a tumor's missed on a chest x-ray and there's an 8-month delay. Well, pretty sure you'll find an expert on radiology to talk about, how it got missed, or maybe there's an emergency physician who didn't follow up on something. But that's a case where instead of just getting that affirmed, we already know that it was missed. Let's start with oncologic causation, because if that 8 months didn't make a difference and it's the same outcome, why are you spending the money on 3 different experts? So there's a lot of things we do to strategically realign. If one expert can obviate the need for 2 or 3 others, let's start there, assuming we've got the ramp and runway to do that. Or if we can consolidate experts. And the interesting time where that occurs, and it's amazing, is often in the personal injury realm. Someone's in a bad, some type of traumatic accident, and they have an eye injury, but they needed a neck surgery, but they bruised their, kidney, and they injured a knee, and maybe they have PTSD. Do I need 8 different experts, 1 for each part, an eye, a knee, an arm? Where can we find consolidation in that? Or how can we stratify which damages we really need to lock down with the top tier voice versus others that are obvious and they can be combined with another expert? So we incredibly commonly take these 5 or 7 experts down to 1 or 2 or 3. And again, we're here to align experts at the end of the day. But I think by building that trust and relationship and education, it just helps everybody to be more effective.
For sure. And that makes it so much more efficient in working through the life cycle of the case, which is so important for trial attorneys, with getting their caseloads down and taking things to trial that are exactly what they need without any kind of bloat, even pre-trial settlement discussions, that sort of thing. Having just what they need, that kind of efficiency is really important, I think.
I agree, and we're not fans of the throw everything at the wall to see what sticks. What we really find, particularly in the medical negligence realm, and by the way, we handle cases anywhere at the intersection of medicine and law, from intellectual property to false claim act to toxic torts, but particularly in the medical malpractice realm, we'll often see just casting blame in 14 different directions. Every single human being did something wrong. I happen to be a fan strategically of just a much more linear approach. Not only is that ethical, evidence-based, and sound, but it avoids just distracting from a coherent case theory and diluting and confusing a jury really at the end of the day when something could be so elegant or just beautifully linear. So we work with legal teams a lot in that realm as well. How do we just get to these core constructs and not go down a tendril?
Right, right. Well, we talked about pitfalls and kind of moving toward the pearls of wisdom there. You had mentioned the ideal expert and what we should look at and consider as the ideal expert. And that's probably maybe where we ought to look at. Now, what would you consider the ideal expert generally?
That is a great question. I look at it as what's ideal for that specific case. So there's no ideal. The chief of Harvard may be a horrific expert for a certain number of cases, either geographically, or maybe they're in a smaller community, or it just appears that you're outgunning. We are so strategic on the elements that go into it. So I think that the core construct to me is sort of the title, I think, of what we're doing today, the battle of the experts. And the question is it a battle? And I'll tell you right now, if you look on Law 360, just in quotes, the battle of the experts, because I did. Now I forgot the number, but I think it's cited over 160 times. And that's just one site. And if you just look at the word battle in legal publications talking about experts, it's everywhere. The point is, it's a battle. And in any battle, the strategy and the tactics, and finally the bigger weapon is usually what's going to win. And I'm huge at just getting the right expert. Our push is typically on university physicians and surgeons. And we've got the proof for it now, north of, 14,000 cases. But university physicians and surgeons are generally coming in with not only impeccable credentials, publications, and everything else, but what I love is that they are the standard of care because they're teaching the next generation. Hard to argue that what they're doing is not the standard. And it's not an ivory tower approach. We don't do that. And it's not getting a professor that's not in the operating room or not in the clinic. Board certified, full-time practicing in the trenches every day in that exact domain with impeccable credentials. That gets you off to a pretty good start in a battle. The reason to me that's so important is that, number one, if you bring in, just a routine private practice or an advertised expert, and the other side brings in a university professor, you're at risk of getting creamed. By the same token, if they've got one and you've got one, now we've got at least two people on an equal tier, and flipping it around, if they don't and you do, you've got a university voice. And again, I'm very careful, not from an ivory tower perspective, but just from a teacher, from someone who's training the next generation, from someone who knows how to convey points because they are educators as well. So I'm pretty big on that strategically. There are absolutely cases where we align private physicians or we help teams work with treaters, but probably 95% of our engagements, starting with university physicians and surgeons, is just where we really, really specialize.
Right. And it seems that you want that perfect combination, right, of knowledge and experience, but then an ability to talk to jurors, to convince them of the case, and to break down complex terminology, especially if we talk about medical malpractice cases, things like that, break down that terminology in a way that the jury can understand. And the attorneys are supposed to do that on their own as well, but it helps when you have an expert that can also do that and really connect with the jury. And that's, I think, having that university professor that has the experience teaching, has the practice experience, but then has the experience teaching as well, really gives you, more often than not, that perfect combination of somebody that can connect with the jury and really teach them the complex concepts that are at the heart of any given case. Is that right?
It does. And I think even through jury interviews, we hear so often, wow, I wanted that surgeon to operate on me, or I'd let that doctor treat me. That's really the highest compliment you can give a medical expert, in a legal proceeding. Is that the person who can tell the story? So the thought is, by the time we've interviewed, the legal team is interviewed, the background's been checked, social media is there, the impeccable credentials are there, and now I've got a renowned teacher, someone who by definition can convey complex constructs. And oh, by the way, they're full-time practicing, board certified, and in the operating room every day. We've teed up someone great. Now, what the facts of the case are, maybe two different things. But by the time we're, getting to testimony, be it a deposition or trial, the hope is we're on the right side of the case. Now it's just a matter of telling that story.
Right, right. Now, you had mentioned before, and you showed me a little bit, the Venn diagram of really digging into that. Could you talk about that a little bit more?
Yeah, the Venn diagram construct, I think, is just interesting because when attorneys set out to find experts, everybody wants sort of the ideal expert. In fact, that's how you started this topic that we're on now. Who's ideal? Or sometimes we'll call it the unicorn. What we're really talking about is a Venn diagram. So we've got the universe of possible traits that can be in an expert. How do we start filtering those out to decide? Because what sets apart one board certified cardiologist from another? So the way I look at it is, within that universe, there's two major sets that we recall our Venn diagram terminology of universe and set and intersection. There's two major sets that we have to focus on. One are the requirements for an expert, and the other is the preferences. And those get mixed up a lot. So requirements are those core things that we can't deviate from. Their specialty, their correct on-point expertise for a case, their licensure, their board certification, their admissibility, whether they've had Daubert challenges or whether they've withstood those. What's their bandwidth? Are they able to take on this case? What's their fee structure? So there's things that might not be bendable at all. And I look at those as requirements, but then I look at preferences. Preferences, how proximate are they to the venue? Other side of the country, closer by? What's their testimony experience? What are their publications? How much do I like speaking with them? We see those things get mixed up a lot. Well, no, I got to have someone who's in this same state, or I have to have someone right here. If there's an actual reason, then yep, that's a requirement. Most often when we talk to people, we see a blurring of preferences and requirements, and we don't want to do that. We want to distill it out. So our goal is to have two overlapping sets, a perfect circle where every preference and requirement is in there. But I won't want to miss the greatest expert in the world because they're 186 miles away, and you were really hoping you'd have someone in the same city. So we walk people through that a lot. And I think when people think about that, it really provides a lot of perspective. The other thing is that we hear so often is, hey, go ahead and send me a bunch of CVs, curricula vitae. That's a nonsensical construct. A CV is no different than if you go on a job site. Okay, now I'm looking at 14 different resumes. Okay, who's the best expert? So to me, that's just not even a starting point. By having a CV, how do you know that person's available? How do you know that they're excellent? How do you know that you'll like it when you speak with them? How do you know anything about them? So a CV is a piece of paper. So we're often walking clients through the process and why it's so important. And if a case isn't worth anything, then yeah, get a CV. Go on the internet and Google expert witness cardiologist, and you'll have 500 of them in 2 seconds. When you take a case seriously, as I know everyone does, then the first serious step is aligning the right assets, and it's doing the due diligence to get the best voice and win the battle of the experts.
Right. And I love the construct of the Venn diagram there, because it really does force an attorney to prioritize what they need versus, like you said, what they would like. And doing that really helps you ensure that you have the best expert, because sometimes a unicorn isn't out there. You might have a better expert, to your point, that's 150 miles away and not in the same city. Well, do you really need that expert just down the block from you? Probably not. That's a want to, not a need. So I do really like that. It forces a focus that sometimes some attorneys may not have when they're just kind of putting down the perfect expert, right?
I agree. And just because someone looks like a unicorn, we still go through the other steps, the interviews, the discussions and deadlines, deliverables, those other things, to assure that you've done everything you can. And it is not a guarantee experts still implode, but it behooves us just to mitigate and minimize that risk.
Now, once you find a great candidate as an expert, one of the things I remember talking with you about before was the cell phone test that you had, and you used that yourself, and I think that's a fantastic test there. Could you talk a little bit about that with in exchanging cell phones as far as experts go and working with an expert?
Sure. So that test, I wish I could say is mine, but I learned it from an incredible trial attorney, Stephen Wigreiser at Salt's Mongaluzzi. And it's something he's done, and we've subsequently incorporated it. So shout out to Stephen Wigreiser. The cell phone test is that once he's spoken to an expert and he's pretty sure he's going to go forward, you can very casually say, hey, doc, let me grab your cell. I'll give you mine. So if you're stuck or I'm stuck or anything, I can shoot you a text, or, just something's getting missed. I certainly won't bother you with it otherwise. And just pause and see what happens. Remarkably, 8.5 out of 10 times, an expert will give you their cell phone. The thought is someone who's willing to do that is someone who is ready to be engaged, who understands, hey, something crazy could happen, the day before trial, or you've got a flat tire, and let's be honest, it's 2023, we all have a cell phone. So he finds that to be incredibly useful, because the opposite of that is, oh yeah, instead of that, let me give you my office number, and you can get one of my assistants, or okay, still might be a great expert. He really prefers knowing that the expert is engaged in this process, and that doesn't seem like a burden since they hand out their cell to everyone else. I find it to be useful now as well. I may have a higher rate of getting cell phones because when we're talking, we're going physician to physician or healthcare provider to healthcare provider. But it's pretty interesting if you think about it that way.
For sure. I think it's a great, quick way to check on engagement, as you said. That's a fantastic test there. One of the things too, as far as discovery, and particularly with complex cases, you will have so much coming through. That seems like that could be a real minefield to navigate with so much information going through. Could you talk a little bit about, once you've engaged an expert, how you manage that flow of discoverable information?
So there's a few things. When we are bringing on people, for example, at my office, I've got 14 people here. The way I explain discovery is that imagine anything you've said in a text, in a voicemail, in an email, and in a letter. Imagine that blown up on a 10-foot by 10-foot slide in a courtroom 3 years from now. Is that something you'd want to be seen? Is it professional? Is it discoverable? Where do we go? And I think once you terrify people, and that's probably something good to do with office staff and everybody else, once people understand that discovery is discovery, we have to be very, very careful. So it's not about hiding things from discovery. It's about assuring everything is channeled appropriately so that there's exactly zero issues with discovery. So when we're working with legal teams, our consulting with the legal team is their work product. We aren't sharing that with an expert. Legal teams don't send us medical records that we then send to the expert, or experts don't send us a report and then we mail it to the legal team. We're not part of that. So we're part of the work product, advising the legal team. And when we align an expert, there's no other discussion of cases or sharing of materials. So there's a firewall that prevents that. So I just encourage people to compartmentalize like that and think of everything. Obviously, attorneys are the experts in the entire discovery paradigm. So it's usually office personnel, experts, other people who can be a bit off, target with that. And even when we're speaking with experts, we're always instructing them about drafts or other things and what can come to us or what doesn't. So if you look at us as facilitating logistics, fine to discover it. I'll send every email I've ever sent. There's nothing to hide. And then our work with attorneys directly is protected.
Right. And as far as attorneys working with the experts on that information and getting that back and forth, that's where one of those instances where communication seems so important as far as setting deadlines and expectations, as far as conclusions of the expert, that sort of thing. Is that right?
Yeah, I think some of that actually comes down to the open-ended checkbook construct. But the point is, there are no doubt experts out there who like to, milk the clock and bill and overcomplicate things, and we see it. Interestingly, again, most university physicians and surgeons don't, because they've got a busy day job. They're not professional experts. So truthfully, they don't want to get a banker's box and spend 23 hours going through it. So I think the flow of information, the compartmentalization, the organization of it, the timelines, chronologies, things we can get into in a moment, all just help the flow of the case and those discussions. So when you talk about discovery, for example, depending if it's state or federal or various circumstances, drafts may or may not be discoverable. Well, what if all you wanted was an oral opinion? Hey, doc, is this a case or not? And the next thing you get back a 10-page report about why it's not a case, and you get an 8-hour bill. You're not going to be happy. But had you explained to the doctor, why don't you do this? Take a look at it, hard stop at 2 hours, dial me up, here's my cell number. Just tell me where you're at. Let's just chat about it right there and find out. That's actually an incredible technique, because otherwise, what if the doctor spent 8 hours to find out that you don't have a case, you're on the wrong side? Or what if the doctor's in the wrong direction? By having, that's one of those speed bumps we had talked about. It lets the doctor know there's a hard stop. And by the way, I don't want anything in writing. It's an oral opinion. It's all of that communication up front. And there's lots of things we can do to prevent that open-ended checkbook or the generation of drafts that we don't need, because either it's a negative opinion and the case is over, so you didn't need it written, or drafts are discoverable. We don't want it in the first place.
And that's so important. So many attorneys come back to your point with that open-ended checkbook sticker shock, and they look at this and go, where did all this time go? Are there any other techniques to kind of avoid that and watch out for that and ensure that you have your expert on a timeline that you're happy with?
Yeah, so I guess two things, just going back to the cost. Let's be honest, physicians and surgeons are expensive, and we see rates going up every year. And there's a tremendous range of what one specialist could be. So one orthopedic spine surgeon could be literally 600 per hour, and another orthopedic spine surgeon can be 2,000 per hour. And we're now seeing our first experts above 2,000 per hour. So that's a huge range. So I'm a huge fan of getting the best expert. So if one expert was $600 per hour and one is $900 per hour, yep, that's a span. But I'd look at that as a distraction if you really need the $900 an hour expert to lock down the case. It's just a margin of $300 per hour. So they put in 20 hours in a case and it's $6,000. That's not going to make or break a case. But if someone's $2,000 per hour, we've got to look pretty carefully how we're justifying that. So we focus on that right out of the gate so that we're not wasting money. But I never want someone to get wrapped up and pick an expert because there's $100 or $200 an hour difference. Those are tremendous numbers. I'm not belaying the differential. Those are real dollars. But in the broader scheme of a case and winning and losing, these are expensive undertakings. Quibbling over that does not make sense. So I look at that as a huge distraction. Very analogous to passing up on an expert because they're 3 states away instead of 2 states away. It's a $100 airplane, difference. So, but the 2 other biggest things we can do to save time, the first are just these prearranged authorized blocks, and it's the easiest thing in the world. Hey, doc, I'm sending you this out. Do me a favor, just because I'm curious what you find just out of the gate. First look, so hard stop at 3 hours. I've included a retainer check. I get it, it may take tons more hours. Hard stop there. Just call me so I know where we're at. You would be amazed how many times you've got either 100% of the answer to your case or 92% or something. And if nothing else, it takes away any surprise about how much more time is required because now the doctor's seen it. Hey, I'll need 5 more hours. Okay, go ahead. But otherwise, you risk a doctor calling you up and then sending you a bill for 19 hours or 41 hours. I mean, we've seen everything. So by having those blocks and letting them know it's not that you're capped at 3 hours. We're not doing that. Just hard stop right there so we can just talk and I'll sort of know what you're seeing. It's actually kind of a friendly way of doing it, but it lets everyone know that it's not an open-ended checkbook. Last thing on that front is that I'm a huge fan. I give CLEs on it, timelines and chronologies to outline, key names, dates, and places. And we hear every day, oh, thanks, but no, we don't want them to have that because that's discoverable. That's discoverable. It's factual. I'm not talking about giving them your notes or, hey, this is the page where they cut off the wrong leg. We don't do that. A timeline or a chronology is just a factual roadmap to the case. The patient was admitted on this date. Surgery was on this date. Here's the operative report. Here's where they're in the ICU. Here's where they're discharged. Here's where they come back 48 hours later to the ER. There's all kinds of ways of constructing those. And what we find is that when you just go, hey, doc, here's the records, and it's a banker's box, or it's 17 PDFs, or it's a 3,800 page set of records, you're paying for someone just to get oriented in there and you're risking someone getting lost in there. Why not have that timeline or chronology done? And again, I'll hear this whole really meaningless discovery argument about it. If it's factual and it's the records and there's no paraphrasing and there's no editing, it doesn't matter. And we still, when we arrange timelines and chronologies, which we can facilitate, we still even stick a disclaimer on. In fact, I'm going to read it off my screen. The following information is provided as a courtesy to facilitate your orientation to various names, dates, and events in the medical record. It's not a substitute for your full and independent review of all case materials. Okay, there's the disclaimer. So when on cross-examination, they go, well, doc, they sent you this timeline and they spoon-fed you the whole case. I mean, you focused on what they told you, didn't you? Actually, no, look at the first sentence in bold. It was given as a courtesy to facilitate my orientation. So yes, I was able to find the operative report quicker than strolling through 7,000 pages. So I guess what I'm saying is there's these common sense things, and it's just incredible how often they're not done. And then people are stunned by a bill for 18 hours. And if someone's billing $1,000 per hour, that adds up pretty quickly. So I really encourage people, just take these simple steps. Again, I call them speed bumps, and they'll pay off on the very first case.
For sure. And it's not only cost effective, it's just, again, it's more efficient toward working that case itself, especially when you're managing, a larger caseload and you have a lot of plates spinning with a lot of different experts, then you don't have to worry about surprises. You don't have to worry about delays, it seems to me.
And the chronology helps you and your team. We all know that, every day or week or few months, you're going to open that case again. There's the chronology. And we love having them hyperlinked. So a hyperlink is, let's say that the chronology is referring to the operation on December 8th at 3 p.m. That's in blue. You can click on it and it takes you right to the page digitally in the PDF where that operation is if you want to look at the report. Or it references the discharge summary. You click on that, it's blue, and there you are right at that, regardless of where it is. Those types of things, you pay a nominal amount for a chronology or a timeline, but imagine you have 5 experts on a case, and you have your team and everyone else. We're all referencing the same things, and we're all just spending minutes here or hours there just finding, but you could be spending thousands and thousands and with multiple experts, tens of thousands of dollars each time they're just looking and facilitating and reacquainting. Timeline pays for itself on day one.
For sure. Now moving into trial, whether trial or deposition, could you give just a few thoughts and pointers on prepping your expert for deposition, for cross-exam, for trial? We've talked about that on Medical Testimony Masterclass so many times, with the proper way of presentation and kind of working with your expert ahead of time to make sure that everything's nailed down. But what would be your top couple of tips on that to keep in mind?
The top tips are just to do it. I am stunned how often there's no preparation, because the thought is, hey, doc, you're great at depo, or hey, doc, I know you know the case. Do you have any questions for me? Here's where we'll meet tomorrow, or let's get a coffee before and let's talk. And then we see things fall apart, and that goes back to that communication problem. I'm a huge fan of running through the entire deposition. And what I mean by that is adversarial role play. So you should be sitting there and you should be set up to take your expert through it, but from an adversarial perspective, so that they can prepare. And you need to ask them all the questions that both of you are most afraid of, because those are the questions that are about to come up at deposition or at trial. So to skirt around them or not hit them head on makes no sense to me whatsoever. And that goes back to that original miscommunication. How can an expert implode on the stand? I mean, there's obviously reasons and times that are beyond our control, but they shouldn't implode for something that was foreseeable or something you were already kind of a little worried about, or maybe it's a weaker spot of the case. Hit those things, ask them in the most terrifying adversarial way, because that's what might happen. So again, it comes back to that dialogue, that practice. I just find that there's no shortcuts in cases. And spending that extra moment of time just pays for itself over and over.
Sure. And one of the things that you've mentioned, and again, in past medical testimony masterclasses, with working with the expert ahead of time is giving them those pointers. If they have something that you think is just off and they aren't presenting it the right way, give them a pointer. I think sometimes trial attorneys are a little reluctant to do that with the expert, a little too reluctant to try and give them pointers on how to explain something or how to phrase something, how to color something. And that's something I think that is important for attorneys to remember, that they can do that. That's part of working with your expert ahead of time.
It is. And if you're ever worried, well, gosh, I don't want to, embarrass the expert, I don't want to be critical, you don't have to blame the expert. Blame a third party. So you can say, hey, a great thought in these environments is that when you're answering, look at me as I'm asking questions, but then gently turn to the jury as you explain. Okay, no expert's going to mind that. Or, hey, doc, I saw, when we're here practicing, your tie is, half open or whatever. What we'll do is, since it'll be a more formal setting tomorrow, a lot of people will be in ties. Why don't you, go ahead and adjust that? So I don't know that it has to be critical, but I wouldn't let anything minor, moderate, or major go off the radar because it felt uncomfortable. I mean, that's your chance to shine, and most experts want to shine and not implode, and they appreciate, in my experience, that camaraderie and that help in getting them, on the pedestal.
For sure. Well, this has been fascinating and really helpful, I think, in discussing, the pitfalls as well as what you can look for to kind of maximize your expert's success there. Are there any other thoughts you have on the topic?
I guess the main thing is, these cases are expensive and they're complicated and there's a lot of tension, but there can be some fun in them as well. And so, these are medical mysteries, the part that you're intersecting with your expert. So I just encourage people to just be present on that journey. You're trying to win, you're doing the best thing for your client, a lot of emotions, tensions, and, pulling issues, but just be kind, communicate, share the journey along the way. This thing about, for example, a case has been going on for 2 years, and you haven't talked to the expert in 18 months, and you suddenly call and go, hey, doc, I'm going to send you records. Why weren't you periodically talking and saying, hey, there's been a pause, and letting you know maybe a few months till I reach out. And then people will be upset. The doctor maybe isn't available or forgot the case. Well, that doctor doesn't even remember the case. So I think treating people kindly, the way you'd want to be treated, is the best secret to success with medical experts. So just good communication, good practice, setting those expectations at every stage, working together, and all of that begins with getting the best expert in there in the first place. So really doing those steps in due diligence, and then following it all the way through to avoid mistakes and maybe enjoy the experience as you're going along. How's that?
Right. Perfect. Well, thanks again for talking with me about this today, because like I said, I really think this is important. So many times medical experts are pivotal to a trial, regardless of whether it's a med mal trial, a crash trial. They are the central witnesses that really determine a jury verdict and how that plays out. And I want to thank again Elite Medical Experts for making this episode possible. Once again, I think you owe it to yourself to check out Elite Medical Experts at elitemedicalexperts.com. If you mention CVN, you'll receive a significant discount off of your first medical expert placement. So thanks again to Elite, and thank you, Dr. Bentley. I really appreciate it.
Thank you, Arlin, and the team at CVN. Always a pleasure.
Thanks.
Appreciate it.